I'm here sui juris in propria persona. I reserve all rights. I, Jonathan Troy Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress, fiduciary advocate.
Before we even get into what you're about to witness, you need to understand something. This isn't just a traffic case, and it's definitely not a normal courtroom exchange. Today's defendant is Jonathan Schuster, a repeat visitor to the courts who identifies as a so-called sovereign citizen. That means he believes normal laws don't apply to him, that his social security number is part of some secret government trust, and that by saying enough magic legal words, a judge suddenly loses power. Spoiler alert, that's not how reality works. What makes this case fascinating is not just the charges, it's the performance. Schuster walks into court armed with a phone full of internet scripts, imaginary legal concepts, and absolute confidence that he's smarter than the judge, the prosecutor, and the Constitution itself. He claims he's not a U.S. citizen, not subject to jurisdiction, and not bound by the laws everyone else follows when they drive on public roads. But here's the twist, the courtroom doesn't run on YouTube law. It runs on actual law. And over the next few minutes, you're about to see what happens when fantasy collides with procedure, when a man tries to argue his way out of reality, and when patience in the courtroom slowly turns into hard consequences.
This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand, so I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying, is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is a Certificate Trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud trust?
Because this is a masterclass in how not to defend yourself in court. Clip 1. Right here is where things start to derail fast. Schuster immediately jumps to his favorite buzzwords: social security, bonds, trusts, commercial court. To the average viewer, that might sound complicated, but in real legal terms, it's nonsense stitched together from sovereign citizen forums. A social security number doesn't magically turn a criminal case into a commercial action. It's simply an identifier used in government systems. What he's trying to argue is that the court is secretly charging a fictional trust version of himself instead of the real person standing there. But courts don't prosecute imaginary entities, they prosecute humans who allegedly violated the law. When the judge calmly explains that the social security number only connects to driving history, Schuster twists that into proof of fraud. This is a classic tactic. Confuse the process, overwhelm the room with language, and hope the court gets tired and gives up. But judges see this every week. And instead of weakening jurisdiction, Schuster is actually strengthening the record against himself by showing he refuses to participate in normal legal procedure.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Now we hit one of the most dangerous choices any defendant can make, rejecting a lawyer while also not understanding the law. The judge offers him 3 simple options: use the public defender, hire private counsel, or represent yourself. Schuster doesn't answer. Instead, he keeps chanting scripted phrases like sui juris and proper person, as if repeating them unlocks a secret courtroom exit. Here's the problem. Self-representation is a legal right, but it's also a legal trap. When you go pro se, the court stops protecting you from your own mistakes. The judge isn't your coach, the prosecutor isn't your friend, and your YouTube research doesn't replace training. Schuster thinks rejecting counsel gives him power, but it actually removes his safety net. Watch how the judge stays patient while still forcing structure. Courts can't move forward until representation is decided. And instead of helping himself, Schuster delays the case, frustrates the process, and puts himself on a path where every future misstep becomes his responsibility alone.
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice, because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm the beneficiary. I am here sui juris and propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or sophisticated trust action. And so I'm here sui juris and propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you, I'm here sui juris and propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're going to have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We can't.
There's no need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
It's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
argument.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July
That doesn't work.
1st.
That date doesn't work
Why doesn't it work for you?
because I'm a man. I have things.
This moment is where the energy in the courtroom shifts from debate to danger. Schuster hears the word bench warrant and immediately reframes it as a threat instead of what it actually is, a consequence. Judges don't issue warrants because they are angry. They issue them when someone refuses to comply with court orders. Schuster keeps pushing the idea that the judge must prove jurisdiction to him personally, but jurisdiction isn't proven through argument. It's established by law, location, and conduct. If you're charged in Washington, for an offense in Washington, committed in Washington, jurisdiction already exists. You don't get to veto it by refusing to agree, and notice the irony. While claiming the court has no authority, he's simultaneously demanding the court dismiss his case. You can't deny power and ask for relief from that same power at the same time. The tension rises because the judge is trying to keep control without escalating, while Schuster keeps stepping closer to real legal consequences.
I've come here multiple times under duress with threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back on July
Are you
1st,
threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't show
You're
up. So
threatening me now.
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st.
Would you like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m., back in this courtroom.
Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're going to threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you your
I'm telling you
options.
this matter needs to be dismissed with prejudice because you cannot prove jurisdiction. This is a
Signature
substantive
here.
trust action.
Signature here,
You're trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're
you
done.
can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more
giving
so
you
than
a
already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is this.
This section might look boring, but it's actually critical. The judge isn't telling Schuster to move to the table for control, it's about the record. Court cases live and die by what's officially recorded. If the microphone can't hear you, legally, it's like you didn't speak at all. Schuster thinks staying back preserves his personal jurisdiction, but that's backwards. All he's doing is sabotaging his own arguments. Courts don't operate on vibes, they operate on transcripts, audio, and filings. If it's not recorded, it doesn't exist for appeal.so. While he's busy posturing about sovereignty, he's erasing his own voice from the legal history of the case. The judge is actually trying to protect his rights by making sure what he says is preserved. But because Schuster views everything as a conspiracy, he turns a basic courtroom procedure into another imaginary battlefield.
No, I have.
Let's address. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster,
I reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Appoint counsel to me
Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Troy Faifuleal Collins Schuster, am here under fraud, menace, and duress. I've made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right
Are you
now,
able to answer them?
I am not here to be interrogated by you. You are
Well, I
under the
just don't
jurisdiction
understand
of this.
what's going on here.
I think you understand and you choose not
I
to
do not
take in the information.
understand
Okay, well,
what's going on
Mr.
here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris in propria persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would,
represent myself.
well, you would. Either you have counsel or you are acting pro
Represent
se.
myself. And so, like I have told you, I'm here sui juris in propria persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an admiralty maritime jurisdiction.
Either. So,
right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I reserve
if you
all
would
my
like-
rights. If you cannot,
If you would like,
I will
if you,
step up so you can hear me better, and I will
none of
speak
it's being,
louder.
none of it's being
I will
preserved.
speak
until you-
louder so you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure the
Mr.
reporter
Schuster,
can hear
you
me.
are making legal arguments. All right? You are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
so-
begin again so that the recorder can
Not
hear me.
choosing to be silent, you're choosing to make a legal argument. So we need to have that on the record.
For the record, I reserve all rights.
You've made that.
I, Jonathan, Troy, Faisal, Lea, Somalia, Toa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Here's the legal reality Schuster keeps trying to outrun. When you drive on public roads, you enter a social and legal contract. You're using government-funded infrastructure, protected by public laws, enforced by public agencies. That's not maritime law. That's not admiralty jurisdiction. That's everyday statutory law. Sovereign citizen arguments love to pretend courts operate like international shipping disputes, but traffic laws don't come from boats, they come from legislatures. When Schuster demands proof of some hidden contract, he ignores the obvious one. Society functions because everyone agrees to basic rules when participating in it. The judge and prosecutor aren't inventing power, they're enforcing rules Schuster already benefited from every time he used a road, a license system, or public services. His mistake is thinking freedom means exemption, when in reality freedom comes with obligations. And the courtroom is where those obligations get enforced.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
we cannot
that
move
is causing
forward.
you to not be able to
To
understand.
challenge my competency, because I have challenged the jurisdiction of this court,
We're
and you
not
have not
We're
proved
not dealing
jurisdiction.
in social security or contract
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court. And
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I've challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Miss Jennifer, can you
I'm
prove
Judge Grant, so I'm going to
Jennifer,
have you.
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training. So that I think is.
That does not matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud. And I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody. And we cannot move further until you've proven
At this
jurisdiction.
point, Schuster starts contradicting himself in real time. He claims the court has no jurisdiction, yet is demanding speedy trial rights that only exist if the court has jurisdiction. He says he never contracted with the court, but has already been on deferred prosecution, which requires agreement to the court's authority. You can't opt out of the system and demand its protection simultaneously. That's like refusing to join a game but still insisting on keeping the score. The judge even points out that this isn't confusion, it's selective understanding. Schuster accepts the parts he likes and rejects the parts that hold him accountable. This is why sovereign citizen strategies fail. They are built on cherry-picking law instead of following it. And every time Schuster talks, the record becomes clearer, not that the court lacks jurisdiction, but that he lacks a workable defense.
So, Ms. McDonald, what I think would be the next steps, I don't know if Mr. Parent, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw as a step.
So we could go through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So, Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice
Denied.
based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, this should be a,
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
So, Mr. Schuster, did the court say that was end of August, or?
it was August 9th is speedy trial.
So,
And if you plan on having me back here, you're taking away from my ability to provide and work.